cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky, we're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people, power back to the people.
Welcome back to W4 Nevada Live's continuing coverage, Day 13, afternoon, with Coyote Springs LLC versus the state of Nevada in a $1.5 billion takings claim case. We are now 4 weeks into coverage. I know it's weird. Day 13 in the afternoon, but literally 4 weeks into coverage. How does that math out? Figure it out, ladies and gentlemen. The court doesn't run every day, sometimes half a day, and we've skipped quite a few days in between, but we are continuing the coverage to bring it live to you because if the state of Nevada loses, ultimately the burden rests upon Nevadans. Also, it will set a precedent that will allow so many cases to come forward as developers have lost on their speculative runs into development, either housing or otherwise. Now, when it comes to water, the water is the public's resource. I don't believe we should ever have to negotiate who or whom that belongs to. Now, the fact that it's been going on for nearly 30 years and it's across multiple different sites, that's the thing that's the most alarming. It's not like, oh, it just happened. So today, where it stands, we've got an update that I put out. We'll go a little bit through that while we're waiting on court to reconvene here at 1:15 p.m. So we opened, and Nevada continued cross-examination of CSI water rights. Got this off to the side here. So we went over CSI's water rights. The state spent the morning trying to narrow in on several places and challenge Richard's central opinion that Nevada historically administered groundwater basin by basin, therefore, or before, orders 1303 and 1309 fundamentally changed CSI's position. But by lunch, however, the testimony had produced a lot more complicated picture than either side's shortest version of the case. Nevada established that joint or multi-basin administration was being discussed before Order 1309, and that the state engineer was actively gathering more science after the regional pump test, and that Order 1303 contemplated a temporary subdivision hold while stakeholders worked toward determining how much groundwater could safely be developed. Richards held to an important distinction here. Whatever Nevada had done elsewhere and whatever joint management meant before 2020 He says he found no earlier example that actually did what he believes Order 1309 did: combine those individual hydrographic basins into the new regional system and then alter the practical priority position of CSI's water rights inside that system. That distinction becomes the battlefield this morning, as Nevada started with two words: jointly managed. Yesterday ended with Nevada confronting Richards on the ruling 6254, which followed the Order 1169 pumping test. That ruling stated that several basins sharing a close hydrologic connection would be jointly managed. This morning, Nevada immediately returned to that language, as Richards clarified that he understands what jointly managed means generally, more than one basin being managed together, but said he still does not know precisely how the state's engineer intended that multi-basin management to operate in this particular system. That's also an important clarification. Richards is not saying the words jointly managed are meaningless. His testimony is that the mechanics and the legal consequences of the phrase were not defined sufficiently for him to conclude that it meant what Nevada eventually implemented through Order 1309. Nevada's argument is increasingly obvious. If CSI had been told years earlier that these hydrologically connected basins would be jointly managed, how unexpected could later regional administration really have been? Richards' answer remains: joint management and the specific regional priority consequences created later are not necessarily the same thing. Then came Nevada's pamphlet. The state moved to 2023, where state engineered document repeatedly described the testimony as a pamphlet, compiling earlier Nevada rulings in order involving the administration of multiple hydrographic basins. Richards had reviewed it while forming his opinions. The apparent purpose of the document was to identify historical examples where Nevada had administered multiple basins together or treated connected areas through shared management concepts. That could potentially undercut one of Richards' most important words from yesterday: unprecedented. Richards had already addressed the pamphlet in his report. His conclusion was that none of the historical examples he reviewed did everything Order 1309 did. According to Richards, the earlier examples did not merge the individual hydrographic basins into the same kind of newly created regional unit. It didn't re-rank practical priority rights throughout the new unit in the same manner, and then restrict pumping based upon that combined regional structure. Nevada walked him through individual examples, attempting to show the multiple basins had, in fact, been administered using shared or joint perennial yield concepts. Richards pushed back on some of the summaries, saying that the underlying rulings did not always contain the language in the summary attributed to them. On one example, he expressly testified an underlying ruling did not support the pamphlet's summary characterization of joint administration. That leaves an important distinction, because Nevada appears to have historical examples of administering related basins together. Richard says that he still found no historical example equivalent to the complete structure created for the lower White River flow system order through 1309. Judge Denton has not yet decided whether that distinction is legally meaningful. Ruling 6254 returned, and Nevada pressed the regional science again. Nevada then went back to ruling 6254. The ruling described the regional system as sharing a close hydrologic connection and discussed a total supply against the Muddy River and Springs rights also had to be considered. The state focused on language saying that the exact amount and location of groundwater could be developed without capturing or conflicting with Senior Muddy River remained unclear. He continued distinguishing at Nevada's developing point. Even the years before 1303 and 1309, the state engineer had not concluded that every already permitted acre-foot could necessarily be pumped indefinitely without creating senior water rights. Richards did not dispute the existence of the uncertainty. He continued distinguishing between uncertainty concerning how much additional existing pumping could safely occur and the later administrative mechanism Nevada ultimately chose to address that uncertainty. That is increasingly the line separating the two cases within this case. The Order 1169 pump test was back at the center stage yet again. The state then walked Richards through the portions of Interim Order 1303 summarizing the regional pumping test. This testimony referenced monitoring from dozens of wells, data collected across several hydrographic basins. One recital described groundwater level decline extending across approximately 1,100 square miles during the testing period. Another discussed approximately 5,290 acre-feet annually pumped from the carbonate aquifer in Coyote Springs Valley, combined with pumping elsewhere in the regional system and resulting changes in groundwater level and spring flows. Richards corrected an important premise in Nevada's questioning. He said he would not attribute those regional changes solely to Coyote Springs pumping. He said the effects described the order represented the aggregate pumping occurring across the tested regional system, not merely CSI pumping in Basin 210. Now, that distinction can matter enormously because Nevada can say the regional pumping tests demonstrated that pumping across the connected carbonate system produced regional effects. CSI can answer that does not establish CSI's approximately 4,140 acre-feet standing alone caused those effects or created a qualified conflict with senior Muddy River rights. The evidence this morning supports the first proposition. It does not by itself establish the second. Order 1303 or 1303 looked increasingly like an unfinished process. Nevada spent substantial time today on what Interim Order 1303 or 1303 was actually trying to accomplish. Richards acknowledged that the order sought additional stakeholder reports addressing the matters, including the geographic boundaries of the hydrologically connected system, interpretation of the Order 1169 pump test data, aquifer recovery, spring flows, and the amount of groundwater that could ultimately be developed without conflicting with senior rights or harming protected sources like the Muddy River Moapa Dace. The state engineer described the goal as collaboratively evaluating how much groundwater could ultimately be developed within the lower White River flow system. Richard agreed that the stakeholders did not participate in this process. He also testified that to his knowledge, they did not reach a consensus. One point became particularly important, as Richards agreed that Order 1303 itself did not impose the later numerical pumping cap that reinforces the Day 7 correction we have been carrying throughout this trial. The numeric limitation did not originate in the text of 1303. The subdivision moratorium got another close look. Order 1303 did address this exact subdivision review. The order imposed a temporary moratorium on final subdivision map review where the state engineer would be required to find adequate water for the proposed permanent development. It also allowed to potential approval where an adequate and sustainable supply for this anticipated life of the subdivision or development could be demonstrated to the state's engineer's satisfaction. Nevada pressed Richards on why the state engineer would hesitate to commit groundwater to permanent residential development while the term or long-term effects on senior Muddy River rights remain unresolved. Richards generally agreed that the state engineer was seeking further information concerning supply availability and potential adverse impacts, but he did not accept every broader proposition, and counsel attempted to attach to Nevada's subdivision law, and several questions drew foundation or legal conclusion objections. Now, for W4Nevada readers, the practical significance is easier to understand than the statutory argument. A golf course or existing pumping can potentially be adjusted later, but a subdivision full of homeowners creates a permanent water service obligation. Order 1303 shows that obligation. Looks like we're coming back. Order 1303 stated that the hydrologically connected areas would be administered as a joint administrative unit, including administration of water rights, according to their priorities were rights located in the other hydrographic basins that previously had been administered separately. That distinction matters because the state repeatedly pushed him to acknowledge the priority table itself is simply chronological. Older rights come first, newer rights come later. Nevada's theory is therefore nobody targeted CSI. If all of these users share one source and supply, Nevada says prior appropriation simply places the oldest rights first. Richards answered for the CSI on the regional priority table. Richards answered in substance, yes. In the sense that when CSI's rights were originally granted under the basin-by-basin system, those other rights were not ahead of CSI for administration of Basin 210. Nevada then pulled Richards' deposition. Richards had previously been asked, in your testimony, should CSI be able to pump in priority higher than those set forth in the priority table? His deposition answer was no. How about that? Richards immediately said he believed there was a difference between the question as posed today and the question asked at this deposition. That exchange matters, and it needs to be reported accurately. It is fair to say Nevada confronted Richards with an apparently inconsistent prior answer. It is not fair at this stage to say Richards admitted contradicting himself or that Honorable Judge Denton had found his testimony inconsistent. Richards attempted to distinguish his context. Nevada will undoubtedly argue the distinction is artificial. CSI will have an opportunity to rehabilitate this answer and get them to explain on a redirect. Richards made another important clarification that the date never changed. Nevada then tightened the language around Order 1309, and Richards agreed Order 1309 did not literally change CSI's priority date. CSI's rights still carry their original priority. His opinion that 1309 changed the relative seniority and practical ability to use the water once the different basins were brought inside the same regional framework. He also acknowledged an important textual difference. Order 1303 expressly discussed priority administration. Order 1309 did not use the same wording to say that CSI's priority dates had been reordered. Richard's testimony is that 1309 produced the effect even though it did not change the dates themselves. That is a more precise description than simply saying Nevada changed CSI's priority date. It did not. That distinction needs to remain locked into our reporting. Now, Nevada also got Richards to acknowledge the door was not completely closed. Another important development. Richards agreed that 1309 did not necessarily preclude stakeholders from presenting additional scientific information showing that pumping in a particular location could occur without harming senior Muddy River rights or protected resources. Richards testified that he himself had not been retained to perform an analysis on demonstrating how much water could presently be pumped on Basin 210 without those impacts. Asked whether CSI or others had performed such work after 1309, he said he did not know. That is useful evidence for Nevada's ongoing finality ripeness argument. The state can say the process was not necessarily closed. New science could be submitted. CSI can answer, a theoretical ability to submit more science does not necessarily restore an economically viable path to subdivision approval after years of restrictions. Honorable Judge Mark Denton has not yet resolved that conflict. Even Order 1309 acknowledged uncertainty and possible future adjustment. Nevada then highlighted language in the later materials recognizing the different areas or the lower White River flow system may have greater or lesser degrees of hydrologic connection depending on the distance, aquifer characteristics, and proximity to the other capturable sources. Another passage acknowledged the future adjustments may be appropriate and the uncertainty is reduced. That cuts into Nevada's favor on finality. The state can argue that the system remained adaptive rather than permanently fixed. It also gives CSI something. If hydrologic effects differ depending on location, then the across-the-board regional number may not answer every question that CSI itself could safely pump from a particular location. That issue remains open in the testimony. And finally, Nevada asks where the 8,000 acre-feet number came from. The morning ended with the number we have heard repeatedly, 8,000 acre-feet or less. Richards testified that 1309 summarized numerous reports and opinions addressing how much groundwater could be pumped from the regional system without unacceptable impacts. He recalled a very wide range among the submitted opinions, approximately 0 to 30,000 acre-feet annually, although that exact range could not be verified or should be verified correctly against 1309 before publication as a final figure. The state engineer ultimately selected 8,000 acre-feet annually or less. Richards agreed that the state engineer reached that number after reviewing the evidence and reports that were submitted through the administrative process. That is where court broke for lunch. Brings us back to where we're reconvening right now. It is 1:22, set to reconvene at 1:15 p.m. Nevada's strongest development this morning is where they substantially strengthened its argument and the regional management did not suddenly appear out of nowhere in 2020. The state now has Richards acknowledging that Ruling 6254 already said connected basins would be jointly managed. The Order 1169 pumping test showed regional responses across a large area. Order 1303 expressly created a multi-basin joint administration unit. Order 1303 sought additional stakeholder science before establishing a long-term pumping quantity. Order 1303 itself did not impose that eventual 8,000 acre-foot limit. CSI's actual priority dates were never changed. Order 1309 did not necessarily bar future scientific submissions. And the 8,000 acre-feet or less number followed an administrative record containing competing scientific estimates. Nevada also confronted Richards with a deposition answer that appeared different from his testimony today concerning whether CSI should be able to pump ahead of rights appearing earlier on the regional priority table. That was a very productive cross-examination morning for the state. Thank you, Mr. Sylvester, once again.
All right, order. Good afternoon, please be seated. That's on the record. The witness has retaken the stand and we may resume. Thank you, Your Honor. Mr. Richards, recall that brief conversation we had with respect to the explicit acknowledgement, at least as identified by Judge Yeager, of the state engineer's acknowledgement that in the future, folks could come forward and demonstrate that water could be used without impacting the down gradient creed for endangered species.
Yes.
Okay. You have your report in front of you still, sir?
Yes.
You turn to page 22 of that report. And you would read into the record sort of the last full paragraph of page 22.
The super basin, excuse me. The super basin created by order number 1309 and the restricted amount of annual groundwater pumping from the super basin, parentheses, 8,000 acre feet annually, close parentheses, is illustrated on map 5, parentheses, see attachment B, close parentheses, provided with this report. Order number 1309 restricted the amount of groundwater pumping within the super basin without taking into account how groundwater pumping in each individual hydrographic basin may affect the muddy river flows, no matter how far away the individual basins are from the river, and no matter how close the wells in the Muddy River Springs area, parentheses, basin 219, close parentheses, may be to the Muddy River.
Do you believe that's consistent with the state engineer's express acknowledgement that there's some uncertainty, and then in the future that stakeholders could come forward and demonstrate water was available without conflict?
I'm sorry, what was the first part of your question? Do I believe that's consistent or inconsistent?
Consistent with your report.
Not really.
Can I have
Your Honor, let me just make a point here and a motion. Council, I think, has now referred to the expert's report, I think maybe 3 or 5 different occasions. And what I would ask the court to do is to admit the entire report now. The report number, I believe, is it 283? 283. And the authority I'll cite to the court is NRS 47120 subsection 1, which provides when any part of a writing or recorded statement is introduced by a party, he may be required at the time to introduce any other part of it which is relevant to the part introduced, and any party may introduce any other relevant parts, Your Honor. This was specifically taken up in Coleman versus State, where on cross-examination, counsel read in part of an expert's report, and the court admitted the entire report for purposes of completeness and being able to put in context all of what the expert was testifying about and what he had said in the report. So my motion, Your Honor, is for the admission of Exhibit 283.
I'd like a chance to brief that, but I will tell you that direct examination counsel read and made portions of the record from that report itself without admitting the entirety of it. I have the right to cross-examine this witness consistent with inconsistencies in the report and his testimony to this court.
Well,
I think your position would be better brought up on redirect.
Okay.
Thank you, Your Honor.
Okay.
Back to 3740, please, Lindsay. I want to just move to 0065, please. And the last sentence of the top paragraph, please. Begins applications. As applications to move water rights under scenarios not addressed in this order will be evaluated on their individual merits to determine potential impact to existing senior rights, potential impact to the Warm Springs area and the Moapa Days, and impacts to the Muddy River. Did you understand, sir, that the term existing rights in that sentence, in that paragraph, relates to both the decreed rights as well as senior statutory rights in the down gradient basin?
I'm not sure I understand what or recall what the scenarios are that are referenced in this sentence.
Okay. To the order portion of it, sir. And in the first numbered order relates to the flow system consisting of, and then it has a listing of those that are to be included. And then at the end of it says that they're going to be established as subbasins within the lower White River flow system hydrographic basin. Do you know what a subbasin is in the context of that paragraph, sir?
Okay. This is a different question from the one that you just asked me about regarding the scenarios.
Yes, sir.
Okay, thank you. Do I know what the subbasins are? Well, they're essentially this sentence is essentially saying we're going to look at what were the original individual hydrographic basins prior to Order 1309, and moving forward, we're going to refer to those as subbasins within the lower White River flow system hydrographic basin.
You finished?
Yes, thank you.
Do you know how a subbasin differs from a basin, if any?
In general, a subbasin would be a part or a portion of a larger basin.
Do you understand, sir, that the water right holders have the ability to seek a change in the point of diversion from where the point of diversion was authorized to make it further distally related to the down gradient decreed rights in the Moapa Days?
I understand that change applications can be made to move points of diversion. Yes.
In the context of this order, in other words, did you understand that a permit holder could attempt to move the point of diversion to demonstrate that it was more distally related and therefore may not impact the down gradient existing water rights?
Oh, the order doesn't say that, but I presume it could be an option.
And then number 2 serves as the maximum quantity of groundwater that may be pumped from the lower White River flow system hydrographic basin on an average annual basis without causing further declines in Warm Springs area flow, and flow in the Muddy River cannot exceed 8,000 acre feet and maybe less. We talked about that. Is there a difference there between a hydrographic basin and a hydrologic basin? In your view, sir?
The words are often times used interchangeably.
Are they synonymous in your view?
Not necessarily.
What would be the differentiation if you have one?
Hydrologic basins, or the term hydrologic basins, is probably more commonly used throughout the water industry. Hydrographic basin is a relatively more specific term that, in my experience, has been used in Nevada.
But in your view, that's a distinction without a difference?
I didn't say that.
No, that's why it's a question. I didn't hear you tell me the difference other than one is more frequently used.
Well, that's my opinion as to what the difference is. One is the hydrologic basin is a term that's more commonly used in the water industry, not necessarily specific to the state of Nevada or any state. And in my experience, hydrographic basin is a term that I've used and seen more commonly in Nevada.
Okay. Item number 4 says all applications for the movement of existing groundwater rights among subbasins of the lower White River flow system hydrographic basin will be processed in accordance with NRS 533.370. Do you know what that means, sir?
Yeah, that means that the applications will be processed and more or less the same procedure as they always have been processed.
Do you know what the statutory reference is to 533.370 is, sir?
Yes.
And what is that?
533.70 is the portion of the statutes that describe the various criteria upon which the Nevada state engineer utilizes to determine whether to approve or reject an application.
An original application or an application to change the manner of use, place of use, or point of diversion?
Yeah, both.
To your knowledge, did CSI ever file a application to change the point of diversion after 1309 was issued? And if I could further limit it as it relates to its permitted rights in 210.
I don't think so, but there may have been some temporary transfer applications. I know there were some temporary transfer applications filed, which are temporary, meaning they're good for one year. I don't recall if those temporary applications were filed prior to or after 1309.
Okay. Sir, do you know whether what the point of diversion is for the Cane Springs permits?
Yes.
And is it in Lincoln County or Clark County, to your knowledge?
Well, there's 4 points of diversion, and they're all in Lincoln County.
Okay.
I should say 4 proposed points of diversion.
Are there wells for those 4 permits, you know, that have
That's
been?
I'm sorry.
You interrupted me.
I know. I'm sorry.
I asked you about wells for the Cane Springs permitted water rights. Are there any?
To my knowledge, no wells have been constructed at the 4 points of diversion proposed in the applications.
When were those permits issued? I'll orient you in time. 5712 was in 2000, I believe 2007.
I think 2 of the 4 were issued in 2007. I'm going to be guessing here, but I think the other 2 were sometime around 2013, 2014, possibly.
Item number 5 on the next page at 0066 reflects that the temporary moratorium imposed by 1303 was terminated. Do you see that?
Yes.
Okay. And then finally, it says all other matters set forth in interim order 1303 that are not specifically addressed herein are hereby rescinded. Did you understand that the all of the other terms not specifically addressed in 1309 were rescinded?
I read this sentence. It, in my opinion, is vague and leaves a lot to interpretation. But yes, I read it, and for what it says, all other matters not set forth in 1303 that are not specifically addressed here are hereby rescinded.
How, sir, did you interpret it when you read it? And again, in connection with it, this order being at least in part foundational to your opinions?
Well, I did compare 1309 and 1303 to make an interpretation as to what other matters that were not specifically addressed in 1309 may be applicable to this statement. And again, there's vagueness to what the statement says, and it's definitely subject to interpretation.
I was just looking for yours. Have you given me what your interpretation of that provision is?
That's certain issues or certain matters set forth in 1303 were rescinded by this order.
And did your comparison, did you look to see, did you form an understanding as to what provisions were in fact rescinded and which were not?
Yes,
Did you learn sort of from that review and comparison that the discussion with respect to administering the priorities relative to other rights in the same basins was rescinded?
no,
And why did that relative priority be also included in 1309 here now?
in my opinion, it was included in 1303. And I mentioned earlier that Order 1303 inextricably links the organization of priority with the statement that the multiple basins will be administered as a joint unit going forward. And so this is, again, is my interpretation. I came to the conclusion that the matter of priority was specifically addressed and not rescinded.
Okay.
And that opinion wasn't just a standalone based on a review of 1303 and 1309. There were other factors that played into my opinion in that regard.
Are you finished with the answer?
Yes, thank you.
Okay. All right. May I please have States Exhibit 3822, please? And sir, you recognize that this is the Nevada Supreme Court decision of Sullivan v. Lincoln County Water District and published at 542 Pacific 3rd 411 in 2024?
Well, it looks different in my copy. Can we scroll through a few pages, perhaps?
Let Lindsay know what you'd like to see.
Continue forward just slowly. Thank you. Okay.
Appear to be that at least maybe not the same form that you've seen, but the same opinion.
Well, again, my copy isn't in the same form or format, but I probably acquired it from a different source.
I don't want to leave a conclusion, but do you understand what the scope of the Supreme Court's decision related to? Let me ask you a better question. Did you understand, sir, that the Supreme Court was asked to determine whether or not the state engineer had the authority to combine the basins into a super basin, at least in part?
And I'm not an attorney or judge. My interpretation was that the Supreme Court was evaluating Judge Yeager's original findings of fact that she issued in 2022, and this opinion essentially remanded two specific issues back to Judge Yeager for further review and additional collection of evidence. And the two primary issues were whether the state engineer had the legal authority to combine the historically administered individual hydrographic basins into the super basin, and two, to determine whether state engineer's determination that 8,000 acre feet pumping cap, that he had the authority to make that determination of the 8,000 acre foot pumping cap.
Finished?
Thank you.
Okay.
Yes.
Go to 0015, please, Lindsay. And to the right, there's a head note 26. You see that? I'm sorry, yeah, 26. And just highlight that, the entirety of that paragraph, please. Now, I know, sir, that you hadn't read this before you formed and issued your expert report in this case. That's correct?
That's correct.
Okay. But you've since read it?
Yes.
Okay. I'm just going to read portions of this in and we'll stop along the way. And that's referring to the Nevada Supreme Court. Do you understand that?
Yes.
Okay. We likewise hold that all of the respondents had an adequate opportunity to be heard on the factual issues. There are no policy or management issues resolved in 1309 such that respondents needed the opportunity to be heard on those issues. Did you agree with that, at least from your own understanding, that no policy or management decisions had been resolved in 1309?
Objection, Your Honor. That would call for a legal conclusion, no foundation.
We can state his understanding of it.
Well, I didn't read this with intention to make a decision whether I agreed or disagreed. I mean, I read it.
Did you not want to know whether or not the opinions that were issued in your report were consistent with the Nevada Supreme Court decision?
Objection, argumented.
Overruled.
It's not that I didn't want to know. I did review Judge Yeager's May 2025 findings of fact before preparing my expert report. You know, I didn't have this Supreme Court decision. I didn't ask for it, and it wasn't provided to me. I had Judge Yeager's final or amended findings of fact, and it summarized what the Supreme Court required. And then I subsequently read the Supreme Court order. I don't think it is inconsistent with what Judge Yeager said the Supreme Court required her to do.
Okay, I'm sorry, did we finish?
Yes, thank you.
Okay. Mike, that's where we started. Did you read it to see if it was consistent? And I think I heard toward the end of your response that you did review it and you found the decision to be consistent with your opinions. Did I get that right from your testimony a moment ago?
Can you repeat that, please?
Sure. The question I asked before you gave that answer that you gave was, did you read it after it was issued and after your report was issued to determine whether or not your report was consistent with the Nevada Supreme Court holdings? I think you said yes, and that you believe it was consistent with your opinions.
Oh, I did not say that. No, I did not say that.
Okay, I'm not trying to put words in your mouth. I'm trying to get an answer to that question.
Okay.
Just so you know, do you remember the question that I've asked?
Yes.
Okay.
And you asked the same question at my deposition.
I did.
Yes. And at my deposition, I said, I'm not an attorney and I'm not a judge. And I can't say whether my opinion is consistent or inconsistent. I will expand on that now because I want to. I think in my reading of 1309, I couldn't find where it said the priority portion of 1303 is rescinded. And as I stated during my direct, I think it was yesterday, I know that 1309 did not rescind the doctrine of prior appropriation. And so I struggled to understand how and why the Supreme Court made the statement that 1309 rescinded the portion of interim order 1303 regarding the priority of rights, because it wasn't explicitly stated in 1309. It had to have been interpreted. My opinion is definitely different, but I know what I reviewed to come to my conclusion. And I don't know if the information that I reviewed was the same information that the Superior Court reviewed. And therefore, I can't say whether my opinion is inconsistent, because I may not have had the same information. And I think that's relevant.
Okay. The Supreme Court says no deprivation of priority property rights occurs because Order 1309 rescinded the portion of Interim Order 1303 that reordered priority rights. Did I read that correctly?
Yes.
Okay. It goes on to say, additionally, there was no loss of flow to any respondent as a result of 1309, much less the quote possible outcome end quote of curtailment, because the findings of the state engineer were purely factual. Would you agree, sir, that there has been no, to your knowledge, if you have any, there has been no loss of flow or possible outcome of curtailment following the issuance of 1309?
I would describe a surface water condition. So I'm not sure how to interpret that.
One of the things that one of your opinions is that Order 1309 took CSI's water rights, I think you said, and gave them to others. Is that correct?
That was practical.
Objection, this state's prior testimony.
You can say so if it does.
I said the practical effect of 1309 and reordering a priority and the consolidation of multiple individual hydrographic basins into a super basin, and then creating a pumping cap over the entire super basin had the practical effect of lowering CSI's relative right to use its water in priority and gave its rights to others to use ahead of CSI.
Okay, but going back to the issue of the loss of flow, sitting here today, sir, do you know, in fact, that CSI continues to pump their certificated water rights?
I believe they are pumping some of their certificated water rights.
Do you know, sir, on that priority table, if all of those both senior and junior water rights to CSI are continuing to pump the water that they've been pumping?
Objection, misstates the record, the facts, and the evidence.
Just asking if he understands whether they're pumping or not pumping.
I don't know.
Well, so then the loss of flow really is a prospective concept that in the future, to the extent that there's a pump cap limitation, CSI might experience a loss of flow. Is that an accurate characterization of your opinion?
No.
Do you have any understanding as to whether or not CSI has experienced a loss of flow from its permitted water rights?
Objection, asked and answered.
Different question.
Well, to the extent that CSI's water rights were permitted for municipal and domestic uses, and those permits were accompanied by specific dates by which the works were required to be completed and the water was to be put to beneficial use and put to beneficial use in accordance with the terms of its permits, meaning put to municipal use. And based on the events that occurred, including the May 16, 2018 letter of Jason King and 1309, 1303, interim order 1303, that was issued a year later in 2019, and then 1309, which was issued in 2020, and then, and perhaps most importantly, Mr. Steve Shell's letter to Amelia Cargill, which was dated June 17 of 2020, 2 days after 1309 was issued, which said that, and I'm going to paraphrase here, but I would like to pull that letter up if we could. That letter from Steve Shell, dated June 17 of 2020, after 1309 was issued, specifically addressed or referred to 1309 as the basis for two things that are in that order, or in that letter. I'm sorry. There were two things in Mr. Shell's letter. One had to do with the lowering of CSI's priority, and one had to do with not approving CSI's subdivision maps predicated on Order 1309. So, yes, I think CSI experienced a loss of their ability to use their permitted water rights under the manner of use that they were granted as a result of these events that occurred between 2018 and 2020.
Okay, but as far as a loss of flow, the amount of water, I think what I hear you testifying to, so you correct me if I'm wrong, is that state engineer wouldn't yet allow them to put that water to a permanent use for a master plan subdivision, at least at that point. Would that be fair?
No,
Did it, Steve Shell, did it say how much water was CSI was seeking?
I would like to pull up Steve Shell's letter if we could, please, because I don't want to mischaracterize it.
Okay, so you don't recall without seeing the document, is that fair?
No, that's not fair.
Okay.
I said I don't want to mischaracterize it or misstate it.
Before we do that, let's finish out what the Nevada Supreme Court said about those issues, or some issues relating to those legal issues and factual issues that were posted forth. It goes on to say, Order 1309 hearing resulted in factual findings as to the boundaries of the LWRFS and the maximum amount of water that could be pumped. And the state engineer did not consider capping or curtailing any individual user as a result of the hearing. Does that comport with your understanding of 1309, sir?
Yes.
They said further, the record is clear that all respondents, including the Cane Springs Valley respondents, were able to provide meaningful input on the factual issues at the administrative hearing. Did you understand that CSI was given a meaningful opportunity to put on evidence at those hearings, if you know what those hearings are?
Yes.
Okay. And then the last sentence in that paragraph says, any findings regarding the maximum amount that can be pumped from the LWRFS were not contemplated for the actual management of individual users and were instead made for future proceedings. You understand what that meant, sir?
Objection, foundation.
Overruled.
Yes, I understand.
Do you understand that 1303 essentially established and set up a two-phase administrative proceeding, generally speaking?
Yes.
First phase was in part to determine the hydrologic boundaries of the basin. Would you agree with that?
Yes.
Second phase, after that was determined, was to determine how much water could be pumped without conflicting with the senior decree rights and the endangered species on the Mother Days. Do you understand that? That is the second phase?
Yes.
Okay. Did you know that second phase has started? Do you know that that second phase has actually started?
In general, it's started. Yes.
And do you know that the state engineer recently, in the first week of July, issued an order designating that basin, the water flow system?
I'm aware of that order. Yes.
You understand what the import of a designation of the basin is from the perspective of the state engineer?
Yes.
You understand that by having the basin designated, it provides the state engineer additional management tools that it can utilize to manage the resource?
I'm not sure if that's accurate or not.
Do you understand that by designating that basin, at some point, the state engineer could designate the basin as a critical management area?
Yes. But it's important to note that all of the individual hydrographic basins that were consolidated and to form this 7 area basins under 1309 had previously been designated with the exception of Cane Springs. So effectively what the order did that was issued this year was designate the Cane Springs basin because all the other basins were previously designated.
But individually, I think.
Individually,
Sure,
yes.
sorry. Your issue, your opinions are based upon the fact that those basins were consolidated into one basin, right?
Yes.
And that single basin was now separately designated as a single basin to allow the state engineer to use whatever management tools it may have available to manage that resource.
Yes, the entire super basin has been designated as a single unit.
And do you know, sir, just from your foundation of understanding the statutory scheme, that unless and until the hydrographic boundaries of the basin had been determined, that the state engineer didn't have the authority to designate the basin as a critical management area?
Objection, calls for legal conclusion, foundation.
I only asked about his knowledge of the statutory scheme.
Same objections.
The foundation.
Sir, you are familiar with and have working knowledge of the the statutory schemes, chapter 533 and 534, that govern the both surface water and groundwater in the state of Nevada.
Yes,
And do you understand, sir, that one of those provisions allows the state engineer to designate a basin as a critical management area?
yes,
You understand that unless and until it's been designated as a critical management area, he doesn't have the tools, if you will, to manage that resource as a critical management area.
I disagree with that.
Can I have, Lindsay, if you would go to 0014. And the last paragraph on the left-hand side. And sir, if you just read that paragraph into the record.
We disagree with respondents' argument that an area must be designated as a critical management area under NRS 534.110 parentheses 7 before the state engineer is authorized to make orders under NRS 534.120 parentheses 1.
And finish the sentence, please, for the paragraph.
Oh, you want me to finish the part that's not highlighted?
Yes, finish the
Okay.
entirety of the paragraph.
There is no indication that an area in quotations in NRS 534.120 parentheses 1 has the exact same meaning as a parentheses critical managed area, close parentheses, under 534.110 parentheses 7. Additionally, it would be illogical and unreasonable to require the state engineer to define a critical management area without first making a factual finding as to the boundaries of the area containing groundwater.
And those factual findings have now been made. Would you agree?
Objection, Lex Foundation.
Sustained.
Sir, when you just read into the record, it would be illogical and irresponsible to require a state engineer to define a critical management area without first making a factual finding as to the boundaries. Did you understand what that meant?
It means what it says.
I know what it says, but in the context of, you indicated 1303 was in part designed to establish the boundaries of the lower White River flow system, right?
No.
Can I go, Lindsay, please, to 0017 and just footnote 6. Says we do not determine at this time exactly how the state engineer is to manage previously granted appropriation rights throughout the subbasins in the lower White River flow system, or whether he can apply a pump cap to individual users, as those issues are not before us. Did you understand, sir, that at least as of that date, the state engineer had not made a determination as to how to manage previously granted appropriations?
Yes.
Lindsay, can I go to 0011, please? And to the right-hand side, 421, you see at the top of that paragraph, just highlight for us. We likewise decline to hold that 533085, and let me just stop for a moment. That's the statutory scheme we looked at yesterday that required the state engineer not to impair vested rights.
Objection, Lex Foundation.
Sustained. You remember yesterday we looked at this particular provision, 533.085, with respect to the need and necessity to protect vested rights.
I don't recall.
Okay. Goes on to say solely applies within a single previously delineated basin and cannot extend across multiple basins regardless of the location of the supply of water without this authority. junior right holders could deplete the shared water resource according to their local priority and previously granted appropriation, regardless of the impact such appropriation has on vested right holders outside of the local basin. Having read that, at least for the first time and again now, do you understand what that means?
I've read it before today. And I'm sorry, give me a minute to study it,
Of course.
please.